This is a lecture about Model Rule 1.9, which is about conflicts of interest with people you used to represent but no longer represent. The fact that someone is not your client today does not mean you're completely off the hook for conflicts of interest discussions or concerns. Because if you used to represent them, you have some remaining duties. Now, the obligations are not as onerous and the rules are not as strict as for people that you are representing right now. But there are still some concerns. And in Model Rule 1.9a, which is discussed in a previous video lecture, we talk about the problem of a lawyer who they end the representation one client. It could be because the client fired you or you quit or the representation ended. And lo and behold, you find yourself either at a new firm or your firm takes on a new client, and it's really the other party in the same matter. And it could be a transaction thing, like a transactional matter, like a commercial contract or business deal or a merger and acquisition or something like that, or it could be litigation. B and C, 1.9b and 1.9c, are really focused on lawyers changing firms. So I want you to think of when you're 2 years, 5 years out after graduation, you've got your first job after law school, now you're ready for a change. You know what you want to do. You know some people that you've met, gotten to know, some other lawyers you would prefer to work with, and so forth. And so you make that big lateral move to your second legal job or your third or fourth legal job. And then that brings up questions of what duties do you owe to the clients that were clients at your prior firm. And that's what that's what Rule B and C of 1.9 are about, and what comments 4 through 7 to 1.9 are focused on. So here's comment 4. When lawyers have been associated within a firm and then end their association, the question of whether a lawyer should undertake the representation is more complicated. There are several competing considerations. And so, in other words, we're going to have a balancing factor here, and these are the policy issues in the background behind 1.9. I think this is, by the way, I have to tell you right now, the next couple of minutes are going to be boring and don't lend themselves to multiple choice test questions. But if you get stumped on a question, it can be helpful to know what's the animating purpose of the rule, because that might give you a hint about a question that otherwise you're stumped by. So first, the client previously represented by the former firm must be reasonably assured that the principle of loyalty to the client is not compromised. In other words, our first and foremost, we want to protect clients from a lawyer who is sticking it to them by changing sides and going and representing the opposing party. Second, the rule should not be so broadly cast as to preclude other persons from having reasonable choice of legal counsel. We could theoretically, I don't want to spend too much time hypothesizing about it, but you could come up with a conflicts of interest rule that is so absolute and permanent that it would end up meaning that every firm has so many conflicts of interest that new clients who just now need a lawyer can't find anyone who will represent them, because everybody has a conflict. And why? Because as the years go by, the firms have represented more people, so they accumulate more conflicts. And we don't want to create access to justice issues for the next generation, let's say. Third, the rule should not unreasonably hamper lawyers from forming new associations and taking on new clients after having left a previous association. The ABA is actually concerned about mobility in the legal profession. They think it's a good thing that you're not stuck forever in whatever job you get right out of law school. And so we like it that lawyers can, after a while, specialize or branch out, or if they work for a firm that was specializing and they want to go do a wider variety of things, all of that is good and healthy. We can end up with lawyers who really develop by specialization a lot of expertise and in-depth knowledge of an area. On the other hand, we allow firms that are poorly managed. Lawyers can leave and go to a firm that's really run well. On and on. We can have private sector lawyers go to and be government lawyers. And we like this. We like the mobility. It's good for our legal system and good for the lawyers. In this connection, it should be recognized that today many lawyers practice in firms, and many lawyers to some degree limit their practice to one field or another. and many move from one association to another several times in their careers. This is a little bit of unsolicited life advice for you if you're a law student right now. The first job you get after law school is probably not what you're going to be doing 10 years later, right? Lawyers change jobs several times in their careers. It's not like going to be like every year or two. It's not that unstable. You're going to get to places and you're going to work there for a while, but firms go out of business, firms merge. You decide that you want to do something else more interesting, a different area of law or something like that. And so we recognize that. And by the way, I got to tell you, I have students all the time ask me for career advice and so forth. And I can tell you right now, the area of law you practice is going to affect your happiness less than the people you work with. And so you should make a list of stuff you know you don't want to do, apply everywhere else. So if you know you don't want to do tax law, put that on your list, and so on. Take the best job you can, I think, after law school. But in the long run, your happiness, you could have your dream job and be doing a type of law that you love and be completely miserable because you work for an abusive boss or your coworkers are jerks or something like that. And so the people you work with are going to have a bigger effect on your happiness than the area of law that you specialize in. If the concept of imputation were applied with unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another and the opportunity of clients to change counsel. Paragraph B to 1.9 operates to disqualify the lawyer only when the lawyer involved has actual knowledge of information protected by rules 1.6 and 1.9c. And so in that sense, and I think I said this at the beginning of the first video to 1.9, about 1.9, this rule is a little hard to teach in class, honestly, because it seems like we're really talking about confidentiality for most of this, with the exception that we don't like lawyers changing sides in the same case by stopping their representation on one side and going and working for the other side. So that's A. But B and C, in a sense, are, as far as I'm concerned, mostly restate duties that are already part of 1.6 confidentiality. Thus, if a lawyer, while with one firm, acquired no knowledge or information relating to a particular client of the firm, and that lawyer later joined another firm, neither the lawyer individually nor the second firm is disqualified from representing another client in the same or related matter, even though the interests of the two clients conflict. Stop. What we're talking, I want you to catch what was just said. Let's say you go work for a big national firm after you graduate from law school. They have hundreds of lawyers. They have offices in 5 or 10 different cities. Really unlikely that you're going to know everything about every case that lawyers in, like if you're in Houston, you're not going to know what all the lawyers in the Chicago office are up to, or all the gritty details about all of their clients. Very unlikely. And so you could, in theory, leave that firm, go work for another firm that happens to be the opposing party, representing the opposing party, from a client that someone in another office in another state from your old firm was representing. No conflict. You don't need consent and so on. This is really a question of how much information do you have. And the bigger the firm, keep in mind, the bigger the firm, the more the potential conflicts of interest grow exponentially. And so because they have more clients. On the other hand, you are unlikely as a lawyer for a big firm to know what all the other lawyers are working on. You're more likely to only know what you and the partners you work for are working on. So this is comment 6. Application of paragraph B depends on a situation's particular facts, not a bright line rule. Sorry, guys. Aided by inferences, deductions, and working presumptions that reasonably may be made about the way in which lawyers work together. In other words, if we have a motion to disqualify you from a case, we're allowed to draw a lot of inferences. We don't have to get into we obviously can't read your mind and find out what knowledge you actually have. So we are allowed to say, well, was this a big firm? Was this a small firm? How much do the lawyers in that kind of area of law know? you're going to find when you're in practice that you could do some quick legal task for someone, filing a letter, filing a form with a government agency or something like that, and really not know much about that client. You don't know if they're married or single, if they vote Republican or Democrat, which sports teams they like, anything about it. You just knew the bare bones what you needed to do that task. And we know that about lawyers. There's other types of law where you are really going to get into all the nitty-gritty details of your client's life and finances and things like that. So now here's a question. A lawyer may have general access to the files of all the clients of a law firm and may regularly participate in discussions of their affairs. And if so, it should be inferred that such a lawyer, in fact, is privy to all information about the firm's clients. So here's our scenario. After law school, if you go work for a small firm where we could fit all the lawyers around a conference table in the conference room, those firms, most of them have regular meetings where all the lawyers get together around the conference table and talk about their cases. This is actually a good thing. You can learn a lot as a new lawyer from listening to the experienced lawyers talk about their cases, and also they can give you pointers about your case if you're stuck on something or you're like, boy, the other side filed a motion of such and such, I've never even heard of it, and they can say, oh, I did a brief about that last week, I'll share it with you. That's very helpful. Also, these types of conversations between all the lawyers in a firm can help flag conflicts of interest that everybody missed, right? So you say, oh, I have to depose this person who's a witness in my case tomorrow, and someone else will say, wait a second, I represent that person in another matter, and it just didn't occur to you to check. And so this is good. The downside of being in a small firm where all the lawyers get together and powwow about their cases is that when you make a lateral move, you know all the goods on all their clients, right? You've heard people discuss in detail all the difficulties, why the client is difficult, why their case is unwinnable, and so forth. So we're going to be more concerned. On the other hand, if you are working for a big firm or a federal agency or something like that, you may not even have access to the network on the network to files of lawyers in other offices. And we can draw inferences from all of these things and decide whether we think there's too much of a risk that you have information. Comment 7. Independent of the question of disqualification of a firm, a lawyer changing professional association has a continuing duty to preserve confidentiality of information about a client formerly represented. And so we're not going to get too far off track with talking about all the particulars of the duty of confidentiality, but for now, one thing you need to know is you have a duty to keep your client's information confidential unless it falls under one of the exceptions or the client has authorized you to reveal it. And that duty continues forever, even after the end of the representation. And so just because a client fired you doesn't mean you get to go share all their secret information. You have a duty of confidentiality that goes indefinitely until the client says it's okay for you to make the disclosure. And that's 1.6, but they're basically incorporating it into 1.9. We have just a couple more points to make, and this is about the 1.9c, which is focused on using information. Again, a confidentiality rule. Comment 8 says, paragraph C provides that information acquired by the lawyer in the course of representing a client may not subsequently be used or revealed by the lawyer to the disadvantage of the client. Guess what? That's also 1.6, the duty of confidentiality. Now, however, the fact that a lawyer once served a client does not preclude the lawyer from using generally known information about that client when later representing another client. And so, you know what? Everybody knows that the Catholic Church is a church. Everybody knows that Texas Children's Hospital is a hospital that treats children, right? So if this is generally known information, everybody knows Michael Bloomberg is a billionaire who ran for president and so forth. So this is, there's information, everyone knows a whole bunch of stuff about Elon Musk, right? So if it's generally known information, or you have a celebrity athlete or movie star or something, and everybody knows their business, then that's not confidential information. Comment 9, waiver. The provisions of this rule are for the protection of former clients and can be waived if the client gives informed consent, and that must be confirmed in writing, of course, under paragraphs A and B. So you don't get to have oral consent to a conflict of interest and so forth. Now, please note that under 1.6, the duty of confidentiality, the client can authorize you to make disclosures orally. They don't have to give you authorization in writing. And here in 1.9, we're talking about a former client, and now there's a concern that you could use that information to their disadvantage. And in that case, you do have to get the permission in writing. Now, 1.6, it would say you can't tell people's information even when it wouldn't hurt the client necessarily, but this is focused on sharing information or using information in a way that could hurt a client. This also should remind you, by the way, of one of our section of 1.8. We have a section of 1.8 that's about using clients' information, but remember, that's focused primarily on while you're representing them. And in that sense, 1.9c overlaps with that provision, but just extends it to former clients. This is a review question that's too long for me to read to you on the video, but I would encourage you to pause the video, read the question, and see if you can answer it. If you're stumped about the answer, this is taken from the restatement of the law governing lawyers, section 132G2, and specifically this question is based entirely on illustration 8. So the restatement gives examples or hypothetical illustrations, and this one turns illustration 8 into a hypothetical question. If you can't answer this, you should look at 8 and maybe consider reviewing the video. If you can, then you got the point from this video lecture.